Oh,
We'll get started when Steve gets back. Well, Mama? What? Oh, okay. Okay. Then we'll wait on them. Then we won't wait on them. We're incredibly accommodating to a point. Good morning, and welcome to this pre-hearing conference regarding the supplemental hearing being held pursuant to State Water Board Order WR 2012-0012, granting in part reconsideration of Order WR 2011-0005. Condition number 1 of the order states, and this is a quote, "The CDO adopted by Order WR 2011-0005 at page 61 to 63 is hereby rescinded. A hearing shall be scheduled to allow Woods customers to participate in as parties, call witnesses, and cross-examine witnesses that have already testified on behalf of other parties in order to supplement the evidentiary record with evidence of water rights held by the Woods customers. The additional evidence will be used for the purpose of considering whether to adopt an order revising Order WR 2011-0005. That's, as you can imagine, pretty scripted, so we will continue. I am State Water Resources Control Board Vice Chair Frances Spivey Weber, and to my right is Member Stephen Moore. We have two staff on the preceding dais. They are Mariana Aoi, who is the attorney, and Ernie Mona, who is staff engineer. And Michael Buckman is making sure the trains are running on time. Evacuation procedure, which is required. Please look around and identify the exits closest to you, and in some cases, an exit may be behind you. In the event of a fire alarm, we are required to evacuate the room immediately. Please take your valuables with you, and do not use the elevators. While staff will endeavor to assist you, good luck, to the nearest exit. You should also know that you can find an exit door by following, and I didn't really know this, the ceiling-mounted exit sign. Oh, that's what those are. Okay. The ceiling-mounted exit signs. Exit down the stairway and to the relocation site across the street at Cesar Chavez Park, or go wherever you want. If you cannot use stairs, you will be directed to a protected vestibule inside a stairwell. Should we have to relocate outside the building, please obey all traffic signals and exercise caution when crossing the street. There will be an all clear sign that for at least for staff to come back over, staff and board members to come back over, and if you are there, you will hear it too. This pre-hearing conference is being conducted in accordance with the notice of public hearing and pre-hearing conference dated November the 10th, 2014. The purpose of this pre-hearing conference is to receive comments on the scope of the hearing and other appropriate procedural issues. The goal of this pre-hearing conference is to ensure that the hearing proceeds in an orderly and expeditious manner. We are particularly interested in hearing your opinion regarding procedural matters that will further this goal of being expeditious and will address issues falling under the general list of topics related to the conduct of the supplemental hearing, which were specified in our December the 19th, 2014 revised list of participation letters, of participants letter. We appreciate the filings of multiple parties to clarify the issues for discussion today. Because this is not a hearing, there will be no cross-examination at this time, and as set forth in the November 10, 2014 notice, the board has scheduled a hearing for February the, February, listen, can't even read, for June the 8th, 2015. You can show up in February, but I'll be in Cuba. So June the 8th, 2015, and continuing, if necessary, on June 9, 10, and 11, 2015. This pre-hearing conference is being webcasted on the internet, and both the audio and video are being recorded, but a court reporter is not here today, but will be here at the hearing. Before beginning, I'd like to make sure that everyone is present. As I identify the name of everyone who has filed a notice of intent to appear and of current parties, I would like the representative to identify him or herself. Please speak into the microphone, and you, as you can tell, you have to speak pretty close to the microphone, and state your name and who you are representing. So we'll start, there's a fairly long list. We'll start with Group A of the represented landowners. And
good morning. This is Jennifer Spalletta from Spalletta Law, and I do represent the Group A landowners.
Group B represented landowners.
Curtis Keller from New Miller and Beardsley, representing what we've termed Group B landowner. Thank you.
There's no valuation between Group A and Group B. The Woods Irrigation Company.
Good morning. Dean Reese here on behalf of General Counsel on behalf of Woods Irrigation Company.
The Division of Water Rights Prosecution Team.
David Rose for the Division of Water Rights Prosecution Team.
Modesto Irrigation District.
Good morning. Valerie Kincaid at O'Laughlin and Paris for Modesto Irrigation District.
State Water Contractor.
Yes, Stan Powell with Chronic Moskovitz representing the state water contractors.
The San Luis and Delta Mendota Water Authority.
Good morning. Eileen Diepenbrock of Diepenbrock Elkin, representing the San Luis and Delta Mendota Water Authority, and with me is my colleague Jonathan Mars.
Okay. Central Delta Water Agency.
Dean Reese here on behalf of Central Delta Water Agency.
And don't turn it off. You've got another one. South Delta Water Agency. They're saving money, you know. The San Joaquin County and the San Joaquin County Flood Control District. Flood Control and Water Conservation District.
Yes, Curtis Keller on behalf of the county and the Flood Control and Water Conservation District.
And Westlands Water District.
Good morning. Eileen Diepenbrock of Diepenbrock Elkin, also representing Westlands Water District, as is my colleague Jonathan Mars.
Have I identified everyone? Everyone that's seated? Yes. Okay, now let's begin. First, we're gonna go in order. We'll start with the motion regarding scope and purpose of hearing. The San Luis Delta Mendota Water Authority, Modesto Irrigation District, the State Water Contractors, and Westlands Water District have submitted a request to change the scope of the hearing to include a definitive determination of Woods Irrigation Company's rights and those of its customers, and to allow approximately 2 months to reach a consensus proposal on a new streamlined proceeding. These proposals would significantly, as you can imagine, change the hearing and matters otherwise set for discussion at the pre-hearing conference, and we do not intend to reach a decision on this proposal today, but as we get toward the end, I will lay out how you will find out the decision that we make on this and several other requests. A brief filed by various landowners represented by Ms. Spalletta responded to this motion regarding scope and purpose of hearing. We will first request comment and discussion on this issue and then proceed with the conference for the rest of the hearing as noticed. Do the entities who presented the motions wish to address this matter at the start?
Yes.
Okay, so this would be the San Luis. Well, you will be, yes, for the San Luis and Delta Mendota Water Authority, and then the Modesto Irrigation District, the State Water Contractors, and Westlands. Do you want to just do Westlands and the Delta Mendota, San Luis Delta Mendota?
Thank you very much. I'll actually be speaking for all of the parties who participated in that submission, and to the extent that Modesto Irrigation Districts Council or State Water Contractors Council would like to add any comment, they certainly will do so. But with your permission, I will take the lead for everybody. The first thing that we want to do is clarify that we don't think we are actually changing the intent or purpose of this proceeding. And so I want to make sure we're all on the same page there. A determination of water rights is essential. The State Water Board and the state have seen the difficulty in administering water rights, especially in times of shortage and drought. And equivocal determinations about based on uncertain evidence are contrary to this very important objective. Even on January 6th, 2015, at a recent State Water Board hearing, the board recognized the importance of gathering actual data to help it in administering the water rights and performing its very important functions. We understand that we are in the context of a CDO proceeding. And we know that the State Water Board is very familiar with the law that governs these proceedings, but I'd like to take a moment to review that framework in the context of setting the record straight in response to the statements from the landowners about their characterization of our request. We are not looking for a full adjudication of all water rights in the Delta or even in some portion of it. We are asking the State Water Board to define the water rights claimed by Woods and its landowners in the context of a CDO under the long-established principles that govern these proceedings. So briefly, and I understand that the State Water Board recognizes this as set forth in its papers related to this proceeding, the State Water Board has the jurisdiction to determine water rights in the context of a CDO. There's case law out there about that, and that's also consistent with the statutes. Under Water Code Section 1825, it is the intent of the legislature that the state should take vigorous action to prevent unlawful diversion of water. To issue a CDO under Water Code Section 1831, the question is whether there has been an actual or threatened violation of Section 1052, whether there's an actual or threatened unlawful diversion. To determine whether there's been a violation of Water Code Section 1052, the State Water Board needs to determine if there has been a trespass, and to determine if there has been a trespass, the State Water Board needs to determine the water rights. So we are asking the Water Board to apply that law to these facts. And we are asking the Water Board to do so based on actual data, not uncertain data, and not make equivocal or uncertain findings about likely water rights. To do that, we think that the Water Board potentially needs to supplement the existing record with all evidence that can be presented by all of the current parties so that the State Water Board can evaluate the basis upon which Woods Irrigation Company claims the right to divert. This is a CDO against Woods Irrigation Company, not anybody else. Woods Irrigation Company has asserted the right to divert based on its own water rights and those of its landowners, and its landowners appropriately now want to come in and provide evidence on that. We believe that all interested parties who have data that will inform the State Water Board as it makes its determination should be allowed to fully participate. So again, we are not asking the State Water Board to make an adjudication. We intentionally stayed away from that word in our submission to the State Water Board. We're not asking for that. We are asking for a definition and a determination of water rights to support the claimed diversions. And that doesn't mean, from our perspective, starting at this point at 77.7 CFS. The record was equivocal about even the right to divert up to that level. And the State Water Board has various findings in its orders about that, and I know this isn't the time to go through all of that, and I will respect that. But again, we are stepping back, starting, and we are asking, establish the rights, whatever level they are, to support the claimed diversions that is consistent with the law and the obligation, if I may say, given to the State Water Board, and we are asking that you apply that law to the actual facts and allow a full participation of the parties on that issue.
Thank you. Thank you very much. Group A, and then we'll follow with Group B, Woods Irrigation District, the Division of Water Rights Prosecution Team, then the Central Delta Water Agency, South Delta Water Agency, and San Joaquin County and the San Joaquin County Flood Control and Water Conservation Districts, in that order.
Vice Chair Spivey Weber, I'm just going to go out on a limb here and assume, people could correct me if I'm wrong, that all of Dean Reese's clients may be similarly aligned, and maybe the prosecution team doesn't need to separate Woods and the landowners from the Central Delta, South Delta water agencies.
Okay.
If their statements would otherwise be the same. So we could change up that order if he thinks that's useful.
Okay.
Yeah, the comments and the perspective from as Woods and of Central and South Delta will be united in the same, so it will be the same comments.
Okay.
All right, thank you, Vice Chair. To respond to what for shorthand, I'll call the San Luis and Delta Mendota parties' request, I do think that the scope of the hearing should be clarified. And it would go a long way, I think, in resolving what I see right now as an ambiguity that's causing a lot of discussion. Frankly, it was an ambiguity that caused the landowners to bring the motions they did previously on the due process issues, because it was very unclear what the intent of the order was with respect to the landowners. For example, was it going to be binding on them? Was it definitively determining the riparian status of their lands for precedential purposes? Where could those determinations be made? Where could those determinations be used in the future? That should be clarified, and we definitely support clarifying the scope of the hearing. What concerns me, though, is that if we do turn this in to a final determination of each of these landowners' complete water rights, riparian and pre-1914, there are serious procedural ramifications to that. Number one, if that is the intent of the proceeding, I don't see how it is practically any different than an adjudication. I don't see the difference between the two. I think there should be an explanation of what that difference is. My understanding is that the San Luis parties want the final determination to be precedential for the purposes of providing certainty and enabling the state board to rely on it for future administration of water rights. That, to me, is the same thing as an adjudication. If this is an adjudication, doing it, making the decision to do it at the end of January and having it occur less than 6 months later for literally dozens of landowners raises heightened due process requirements. There obviously would be no opportunity for meaningful discovery and depositions prior to hearing, and that, I think, is a serious issue. I also don't know that it's really the intent of the board with its CDO. It seems to me that the cease and desist order was aimed at curtailing diversions beyond a certain point because the state board did not believe that Woods or its landowners had water rights that would exceed a certain point, a certain limit of diversion, and they wanted to nip that in the bud. I can understand that in the context of a CDO. There are a lot of aspects, though, of water rights that go beyond just a pumping limitation. Seasons of diversion, source of water, availability of water at the source, priority and relationship between other water rights on the same stream system, defining what the stream system is. These are all nuances and difficulties that go into final determinations, binding precedential determinations of water rights that I don't believe the state board prosecution team is prepared to present evidence on, and I don't see the necessity of doing in the context of a CDO. And let me give you an example. If the landowners are able to come in and put forth evidence to convince the hearing officers that the pre-1914 right is actually something that should be measured on a 30-day average as opposed to an instantaneous measurement, and that at 77.7 on a 30-day average, that more than covers what they've historically diverted and what they've diverted today. Let's say we're able to convince the hearing officers of that, and the hearing officers felt comfortable issuing a CDO based on that limitation. There would be no reason to get into the riparian right determination for each individual parcel. But if the state board hearing officers decide they do want to get into the riparian right determination of each parcel, and they reject some of the contentions or assertions of the landowners, that will probably lead to appeals. And it would mean delay in implementation of a cease and desist order for a pumping limit. So I think the state board really should think carefully about the intent of this process and whether it really is a cease and desist order process aimed at achieving a pumping limit, or whether it's supposed to be an adjudication of water rights. If it's supposed to be an adjudication of water rights that's final, determinative, and precedential, I would submit to you that that is the equivalent of an adjudication. It should be spelled out clearly for the landowners so that they know what they're getting into. Right now, like I said, I think it's ambiguous. The clarity would be appreciated. The heightened due process requirements should be respected. And I think that, frankly, the state board would probably want some time to do some investigation and actually be prepared to put on different evidence. So those are my comments for you. I do disagree with the San Luis parties about the reading of the two cases they cited, Millview and Young. I mean, I obviously argued in the Young case that you did not have jurisdiction to determine the riparian and pre-1914 rights, at least in the context of a CDO. I lost that argument at the Court of Appeal. I respect the Court of Appeal's decision. But I don't believe that the Court of Appeal in Young or in Millview went so far as to say you could turn a CDO hearing into adjudication of water rates. I think what those appellate judges said is you have to evaluate the scope of evidence to support the riparian and pre-1914 right so that you can determine where that limit is, the pumping limit is, for the purpose of issuing your cease and desist order. But that's it. They did not get into all the details and nuances that would be required for a full adjudication of these individual water rights. So with that, are there any questions that you have for me?
No, thank you.
Thank you.
Yeah, for the sake of not being repetitive, the landowner group B and as well as the county will be supportive and with the comments made by Ms. Spalletta.
Good morning again, Dean Reese on behalf of Woods and Central and South Delta Water Agency. Woods and the agencies are also supportive of the comments and the position set forth by Ms. Spalletta. I would just add a couple of things. We are not in agreement, obviously, with the proposal to expand the scope of the proceeding. It's unclear how this process could withstand judicial scrutiny if we were to do so, or even if we weren't to do so, because there hasn't been a CDO issued against the landowners. We had a CDO issued against Woods, and here we have landowners who need to participate only to the extent because if the matter is going to go forward, their rights can be determined and affected. Then you have landowners coming into a process where the cart has been put before the horse. There is no CDO against landowners. Such a CDO, or a draft CDO, such a CDO would require investigation. It would require the ability for the landowners to know exactly what the basis of the draft CDO is, and we don't have that here. So from Wood's perspective and the agency's perspective, we think that the board needs to take a step back and figure out if they're going to issue a draft CDO against the landowners in the first place. So with that, I'll save any further comment for later.
Thank you.
This is a theme you'll probably hear a lot, is that I don't necessarily agree with one party or the other. And I'll keep this pretty brief. I think a couple of points I just want to provide the prosecution team's perspective on. We don't completely agree with Ms. Spalletta's reading of the Young and Millview cases, and I think that those cases do allow for the board to make a full determination of what the water rights are in order to determine whether an unauthorized diversion is occurring. But that doesn't mean that just because the board can, it should. The proceeding that we have here is a CDO proceeding as it was initiated by the prosecution team with the draft CDO, and I will agree in general with Ms. Spalletta that our intent when we initiated this was that there was evidence in front of us that we thought showed an unauthorized diversion by Woods to its landowners was occurring. There was approximately 90 CFS that we measured, and we didn't think the rights covered that. So our concern was not determining what everybody's right exactly was. That seems difficult and time-consuming, and we certainly acknowledge that it's necessary to have some sense of what those rights may be as to determining finally whether an unauthorized diversion may be occurring. But this was initiated as a threat of unauthorized diversion, not an actual necessarily unauthorized diversion. So I don't agree that the board has to determine everybody's water rights finally in this situation for a CDO to issue. I believe the questions that are asked in this newest notice are somewhat different than the questions that were in the first notice of this hearing. But in the first notice of the hearing, the questions, I believe, were essentially, is there a threat of unauthorized diversion? And if so, should a CDO issue? And I think that those are the questions that the board could still answer here. It could potentially, depending on the evidence that comes out, go further as advanced by most of the parties represented on my left. But I'm not sure, I don't think it's our perspective that you have to. I tried looking into a little bit more what positions the board has taken in the current stayed litigation, which I believe the parties on both sides of me are trying to get maybe a little bit more towards the certainty of the rights than may happen here. But I don't have a strong opinion about that. And I couldn't quite tell because I'm walled off and don't talk to any of you about what's happening there. But I think that the board can go in either direction. That's our perspective from looking at it, is that if the evidence allows you to, you could do something like an adjudication, although there are probably limitations as to how close it could get to a real adjudication, rights relative to each other, rights relative to people who aren't parties. It would just be a limited adjudication as to the parties who are participating. But it's not our perspective that's necessary, and that's not what we were initiating. The ball is now out of our court. It is largely in the board's court to determine what you want to do. I don't think we have a lot more evidence that we could put on one way or the other because we started with the threat of unauthorized diversion, but certainly the evidence will be coming from everybody else. So that's neither here nor there, but that's our perspective as to how we initiated this and our perspective on what's been alleged in the briefings that you got. I just wanted you to have that.
Thank you. Steve, do you have any questions or opining based on what you've heard?
Well, I want to thank the parties for presenting their case. We've had a chance to review your briefs that you've submitted, and your testimony is consistent with the briefs that you've submitted. And appreciate the discussion of the scope of the hearing. I'm inclined to
Stick with it.
stick with the scope of the hearing that we've just discussed. I would, we could state this a number of different ways. I wanted to invite, before actually wrapping it up, I'd like to hear staff's response.
I don't have anything to say at this point in time. Thank you.
I just based on my review of the information, I see the ambiguity that's been discussed in terms of a definitive determination versus evidence presented in the CDO context, and so I think that's there's a difference in my mind between those in terms of what's definitively and as Ms. Spalletta says, that is that really a difference, a definitive determination of water rights versus an actual adjudication? I guess that's part of the uncertainty that we dwell in because of the 1914 line that was drawn historically. And so we're reckoning with that. There is, I respect and recognize a prosecution strategy that I've seen in the record where, there's sort of that gray area and then there's black and white. And there's a prosecution strategy to use enforcement proceedings on what is black and white as opposed to what's gray. And so I just want to recognize that. And I feel more comfortable with the scope of the hearing being limited in that way to really look at what's clearly above what evidence in the record suggests is a water right pre-14 or riparian. But that's just my opinion.
Mariana, do you have some questions of the witnesses?
Yeah. If I may, the attorneys. No one's getting cross-examined here. Yeah, I mean, something I thought was interesting about the motion, and just to let you know that there is going to be more discussion about the scope in terms of assuming we don't change sort of the intent of this from a CDO hearing against Woods Irrigation Company. That's sort of how we've set up the rest of it. And there will be more discussion about some of the ambiguities that that Ms. Spalletta has called up about uncertainty that the landowners have about sort of what this proceeding means and the status of drainage-only customers and things like that. But we thought it made sense to first talk about this larger issue, because we do actually see that as a departure. And I understand the argument now better at oral about that's your understanding of what the CDO required in the first place. But I was interested to hear what you mean by a definitive determination that would be precedential, and how that would be different than an adjudication of the rights.
This is Valerie Kincaid from Modesto Irrigation District. My understanding, and I think that's a question that a lot of people have here between an adjudication and a definition of rights, is that a definition of rights is one party saying you have this right for this season from this river, defining your point of diversion, your season of use, your amount of use, your rate. An adjudication is a group of landowners, and there's usually a physical solution involved, which means you can take into consideration their right, whether it's riparian or pre-14, their historical right, but you usually provide a physical solution, which means it's not necessarily this is your right and this is what you get all the time. It provides for shortage. It has certain people agree to take less than their actual right. That's what most adjudications have. It's like, you could prove 100 CFS, but you'll take 80 because this is an adjudication. And so there is a distinct difference between an adjudication and what the parties decide to do and what the parties decide their right going forward will be, compared to what their definitive, what they could actually bring evidence and prove up as a historical pre-14 or riparian right. So from my perspective, that is the difference between adjudication and a definition. And in this situation, you wouldn't necessarily need to do an adjudication because you're not coming together and talking about specific landowners with a specific cap of water and dealing with shortage provisions. You would just be saying, this is your right as you can prove it. There are specific requirements in proving a riparian right and a pre-14 right, and if folks step up and prove the requirements, then you either have it or you don't, and the extent to which you have it and the season to which you have it is defined. So from my perspective, that's the difference between the two. It's not technical, but I think generally everyone understands that's how I see the difference, and I think that's how you could define specific rights here and not do a full adjudication. And then if I may just make one other comment that again is a more general big picture comment. When you're talking about a CDO and defining rights and a CDO and just telling people kind of a limit that they have to back off from, a lot of the legwork you do is the same. And from my perspective and my experience in the Woods decision and what came out and fell out of the Woods decision, the issue becomes that you do all this work and without a definitive decision, you kind of just you go up to the finish line and then you kind of fall short. And that's what everyone was fighting about in Woods. You walk up to that line of defining a right and then you step back and you don't define it. And then that caused everyone to argue about what that means and what impact that is. And from Modesto Irrigation District's perspective, certainly their goal in this is to get certainty and to really understand what people have, what season they have it. And from our perspective, without defining those rights, you really don't get to that certainty hurdle. And it would definitely be our goal to have everyone come away from this understanding the limitations and the rights that folks have. And from my perspective, to walk up to that line and do all this work to CDO and then not define them seems like just a kind of a bad investment of time and then not taking that final decision. So I'll leave it there.
If I may, Eileen Diepenbrock for Westlands and the Authority. We support everything that Ms. Kincaid just said, and also stepping back up to the 50,000-foot level, if I may. Again, this is a CDO, and we recognize it. And the board will issue an order, and the order will or will not be a CDO. The board needs to understand the rights, to define the rights in order to do its job to issue that order. That's what we're talking about. And it can't be based on equivocal findings on uncertain evidence.
Jennifer.
Thank you very much. I do agree in part with what Ms. Kincaid said about making a large investment and not reaching a final determination. However, how the hearing is framed to give the parties notice and opportunity to be heard becomes extremely important if the end result is going to be the final determination that she suggests. Now, these parties, if they have a strong interest in obtaining this final determination, could file a lawsuit or trigger a adjudication under Water Code Section 2525 and could ask either this board or the court to make those final determinations. However, they would more than likely draw a cross complaint for a final determination of their own rights. And what I find somewhat unsightly is the idea of having parties who wish to limit the rights of certain water users on the stream using the state board's CDO process to obtain that goal while insulating themselves from similar determinations. And so I think we should be very mindful of that, that the state board conduct this proceeding in a way that achieves the goals of the state board using a CDO process and is not used to achieve water right determinations sought by others on the stream who are insulating themselves from similar scrutiny by having the determinations made in an isolated CDO as opposed to an adjudication. So that is a very serious concern of mine, and I hope one that the state board takes into account.
Any other questions or comments? Sure. We could, well, should we move? I think what we'll do, because I think a big piece of the request, to some extent on both sides, is to clarify what it is we're doing and why. And so before we make a ruling on this particular issue, even though it will significantly change the way in which we're proceeding, let's move on to discussing the scope of what was proposed or what has been proposed. And the noticed key hearing issues, to see if among us we can conclude whether or not it's adequate to moving forward. The hearing issues that we proposed were, should the original terms of Order WR 2011-2000 or 0005 be modified or readopted based on supplemental evidence, cross-examination, or arguments that arise as a result of the supplemental hearing. And two, what, if any, evidence is available to substantiate valid water rights held by Woods customers beyond the evidence that was provided during the hearing in 2010. There appears to be confusion as to the reason for including evidence regarding the landowner's water rights in the key issues. The hearing, as noticed, is for the sole purpose of determining whether to issue a CDO against Woods, and if so, what is the content of that CDO. No CDOs in our are being proposed to be issued against individual customers. At least that's not how we're entering this hearing. So the individual customers will not be receiving, would not, in our opinion, be receiving a CDO. There also appears to be some concern, lingering concern, regarding reopening the CDO process rather than starting the hearing over. I want to take this opportunity to assure you, all of you, that all of us up here on the dais, my fellow hearing officer, staff and I will thoroughly review the existing hearing record, and it's extensive. But we promise we will be going through every dit and tittle of this of the work that was put into the existing hearing record, as well as any new evidence submitted prior to the hearing. As many of you know, I was here for the first hearing, and in 2010, and but I too will be not relying on my memory. I will go back and read everything. Landowners and Woods have submitted a joint petition requesting that the drainage-only customers be removed from this proceeding, and the prosecution team has submitted concurrence. We will be issuing a ruling on that later, but that right now that has been requested, and the prosecution team has concurred. We'd like to hear any comments or questions regarding the scope and purpose, if this in any way changes your position on the earlier question or otherwise, as noticed, and on the joint petition. So let's start with the Group A and Group B.
Thank you, Vice Chair. I will address the key issues as they're phrased. I think that, frankly, they should be flip-flopped, and that the first question that should be asked is similar to what's framed here as number 2, but it should be a little narrower. And this gets to our petition to exclude the drainage customers. The State Board uses the term Woods customers. I think thinking in the State Board's mind that those are the landowners who receive irrigation water through the Woods facilities. That actually is not true. Woods has drainage customers. So when Woods submitted the list of people who receive services from it, it necessarily included those lands who are drainage customers. So this, I think the first question should be, what evidence is available to substantiate the water rights held by Woods Irrigation Company or the landowners that receive water through the Woods Irrigation Company facilities, beyond that which was submitted during the prior hearing, that would support the current magnitude of diversions. So that's what I think the first question should be. And then the second question should be, considering that evidence in light of the evidence that was put on in the other hearing, should the draft CDO issue? And you'll notice that I am phrasing it in the context of should the draft CDO issue based on the evidence presented, as opposed to saying, should we amend our prior order? And to me, there is a significant distinction in that, because I appreciate what the Vice Chair has said, which is that you were present at the prior hearing. You take seriously your job to review all of the evidence prior to issuing a decision. If that is truly what you are going to do, you do not need the prior order as a crutch. I mean, you should be looking at all of the evidence, making a fresh determination, and I think that if you do that, it will go a long way toward satisfying the due process requirement. So that is how I would think that this should be phrased. If that is how it's phrased, then de facto the drainage customers would no longer be parties. And that is what I would suggest. Now, I want to just clarify for practical purposes why it's so important that we not include the drainage customers. The drainage customers divert water from other places. Some of them divert from places that aren't even Middle River, where the Woods diversions occur. They base their rights on other historical facts, okay? So if you are going to include a determination of the water rights of all of these drainage customers in this hearing, we're going to be here for longer than a week. And I'm probably going to have to amend my notice to appear to include other witnesses. So we're talking about a significantly larger, more complicated hearing. Frankly, I think it's complicated enough. So I just want to make that clear, that we are talking about different diversions, different factual circumstances, different lands, and it really doesn't relate to the Woods system at all. Thank you.
Do you want to? Sure, sure.
How, and this may be, I'm trying to phrase this in a way that we're not getting too much into the evidence, but the drainage customers are within the area originally set out in the 1911 contracts, correct?
No.
Okay. Thank you.
There may be one or two parcels that satisfy that criteria, and for whatever reason, they're not receiving irrigation water through Woods because they have a different system, but the vast majority of the drainage customers are not. And that's correct, right, Dean?
That is correct.
Okay, yes. He knows the service area better than I. That actually is an important issue. It's one that I hope we resolve through our factual stipulations, is the term Woods service area, quote unquote, was used in the prior decision. It has been used by the state board. I don't believe that everyone's on the same page with what that means. And one of the things that we are doing is preparing maps so that we can hopefully reach stipulations with the state board prosecution team and the other parties about exactly who gets irrigation water, who gets drainage water, how that relates to the 1911 contracts, so we're all factually on the same page. Yes. Something that you may or may not know is many of the drainage customers actually have post-1914 State Water Resources Control Board licenses to divert from San Joaquin River or Burns Cutoff, for example. So they just the drainage facilities extend beyond